The decision was just made by the judge. The judge hasn't provided us with the written judgment, so we can't really comment on all of the findings by the judge or the reasons as to why he ultimately made that decision at this point in time.
In the in the in your presentation, when the judge asked you who was the Minister of Natural Resources, you replied to him that you did not know who was the Minister of Natural Resources. Were you attempting to mislead the court?
No, there's no such thing as us misleading the court in respect to that question. I think you completely misunderstood that question. When it comes to making a submission to a court, one has to rely on evidence that is provided from the witness box. What we indicated to the court was that in the witness box, there was no evidence as to who at the time was the minister involved. It has to be recognized by yourself, perhaps because you're not trained in law, but one cannot give evidence from the bar table as the attorney. We can only speak to what is said from the witness box. So that's the point as to why I had indicated that I can't give evidence to that. It can only be from the witness, and that wasn't provided by the witness.
It wasn't. But the judge was aware of it, and he made several references to it during his judgment.
Well, that's why we're waiting to see what's in the judgment. But again, the purpose for which that was said was to explain that as attorneys from the bar, we cannot give evidence and we cannot speak to anything that's beyond what was provided
No,
in the witness.
He was asking you a question, a direct question.
I think you misunderstood. I think you
resources at the time of the transaction. That's what the judge asked you.
No, I think you're mistaken as to what the purpose for which the question was brought, though.
No, sir. What is your client's position at this time? Can he return this money?
I haven't spoken to the client in respect to the return of any funds at this point in time. Again, we are waiting for the decision to come out in writing, and then we will be going through the judgment and the contents of the judgment and the reasons, and then we will decide as to whether or not we will appeal. We do believe that there are many grounds to appeal, and we do believe at first instance that we will appeal.